Hello everybody, thanks for clicking through to this bite-sized introduction to intellectual property. Now my name is Graham Carter and I'm the Intellectual Property and Spin-Out Development Manager at Robert Gordon University. Now let me introduce you to Ella. Ella is a crested macaque and some years ago now took this rather excellent selfie. And in doing so, she sparked off what became known as the monkey selfie case, which at its heart was a dispute about intellectual property. Now we'll come back to Ella at the end of this presentation, but to begin with, let's start thinking about what is intellectual property. So let's get one thing cleared up straight from the bat. There is intellectual property, or IP, and there are intellectual property rights, or IPRs. So what's the difference? So IPRs are frameworks in law which come in a number of, shall we say, flavours. So there are patents, there are trademarks, there are design rights, and there are the laws of copyright. Now, these are rights under law, meaning that owners of those rights have certain protections under the law. Now, in addition to those, some people like me will also consider things like know-how and trade secrets to be a type of IPR. And strictly speaking, they're not. They certainly can be transacted, they can be licensed, they can be bought and sold. So I always count them in as a type of intellectual property right on my lists. So what is IP? Well, the true answer is that it's almost anything which is the output of your creativity. An idea of itself is not intellectual property. That idea must be expressed or manifested in some way for it to become intellectual property, and then onwards to an intellectual property right and stand some possibility of protection under the law. So if you're a software engineer, that code you've just written is IP. Similarly, that poem, that piece of music you just wrote, or that song you just recorded are all IP. This video can be said to be a piece of intellectual property. Patents cover inventions and processes. So if you own a patent, you have the right to stop others from making, using, or selling your patented invention or process in the country for which you have a patent. Generally, your patent right extends for a period of 20 years, during which time you can control the commercial exploitation of your invention. It's sometimes referred to as a monopoly right. Now, patent rights are expensive to establish and maintain and are not something you'd be wise to set out on establishing without consideration of a wider commercialization plan to ensure that you have a chance of getting a return on your investment. Patent is a powerful right commercially. They can provide significant strategic value to tech-based startups and university spin-outs as they help build credibility and provide a rallying point to leverage investment. For established companies, particularly in medicine, where there are long lead times to product development, and other highly competitive sectors, think Dyson or Apple, where market share and market differentiation are hard won, patents play a big role. Of all the IPRs, patents are certainly the one where expert advice should always be sought. So a word about trademarks. If you own a trademark, you have the right under the law to stop others from using that aspect of your branding and trading off your good name. Trademarks are therefore intertwined with how companies brand themselves and project their persona into the marketplace. Now, trademarks can be powerful commercially, especially if you've invested in getting your trademark formally registered. Because unlike patents, they can be renewed typically every 10 years in the UK. And this means a trademark can long outlive any patents on a product. Imagine how much the Nike swoosh or the Adidas 3 stripes are worth to their owners. If you are the copyright owner of a piece of creative work, maybe some software you've written, or a photo you've taken, or a song or poem you've written, you have the right to control how your creative content is released to the world, who can use it, who can exploit it, and possibly how it might be monetized. Intellectual property is a class of asset referred to as an intangible, and this does not mean that it has no value, cannot be traded, bought or sold, or stolen. The various types of intellectual property right provide the legal frameworks around which intellectual property can be transacted and protected. You might be able to see, therefore, that multiple intellectual property rights can be drawn from and mapped to a single given piece of IP. So that song you wrote will be copyright. A recording, performance of that song may be subject to performance and recording rights. Both performance and recording rights are both categories of copyright. So a single product will commonly have multiple IPRs associated with it. Let's consider this iPhone. It's one product, but you can be sure there are many different types of intellectual property rights surrounding this product. You can bet that Apple own or have licensed maybe a few hundred patents protecting the underlying technology and engineering aspects of what make this phone work. There are multiple trademarks in there. There's one on the back. You can see immediately it's not a Samsung phone. There'll be copyrights in there, and the sounds that it makes and the fonts that it displays. There are design patents in there protecting the whole look, shape and feel of the phone. And if we consider an exhaustive list of IPRs that surround this product, you can be sure that there's a whole heap of know-how. There's likely to be some trade secrets in there as well. And that's before we even consider the materials and the manufacturing processes that went into putting this thing together in the first place. So to summarise, what have we covered? Firstly, that intellectual property is an output of your creative activity. Secondly, that intellectual property can be protected under a number of different legal frameworks called intellectual property rights. Examples of IPRs are patents, trademarks, design rights, and the laws of copyright. And we've also discussed that one product can be protected by many different IPRs, and that IPRs can be powerful commercial tools to help drag in investment and or provide a market differentiator against competitors. Now, one very good thing about IP and IPRs is that there's a wealth of good practical information available for free online. But do take care to source information that is relevant to your country or territory. Laws do differ between countries. Now, as we are based in the UK, I'm going to recommend the UK Patent Office website as the first place you should go. Now, although it's called the Patent Office, be assured that it covers the full spectrum of IPRs, with various toolkits, animations and video content explaining, I think, very well this subject matter. So to finish, here's a poser for you. A monkey walks into the jungle, finds a camera and takes a selfie. Who owns the copyright in the selfie? Welcome back, Ella. Now, ownership of IP is something I've not covered in this session, but it's actually a very important and significant consideration. This is especially so if you're expecting to create value in your business from an IP-based asset. This is probably a topic for another time, but for now, the monkey selfie case. A photographer called David Slater was working in Malaysia on a wildlife conservation project. He set up his cameras in such a way that the wild macaques interacted with them and captured a whole series of spectacular close-up images. They were so good, he released a few of them to a news agency as a press release, and they were picked up by lots of the newspapers and Wikipedia. Now, Slater wanted Wikipedia to take down the images on the grounds that it did not hold the copyright, and his income had been damaged by no longer having control of how the images were used in the public domain. He found out in court, however, that although he had clearly engineered the creation of the images, and at a real level is their owner, the laws of copyright do not apply. In the jargon, the images are not a creative work because they lack a human author. Now, around this time, a second somewhat bizarre case was brought in the name of a monkey against David Slater. The organisation People for the Ethical Treatment of Animals alleged that the photographer was attempting to remove rights from the monkey. Now, this case was dismissed. So these selfie images could be looked on as data captured by a sensor. They're still an intellectual property. They constitute part of a wider package of results relating to the conservation project. At some point in the future, they may well be spooled up into a wider body of work, such as a book or a film documentary, and in which case will become subject to copyright-based intellectual property rights. So as pieces of data, they are analogous to results in a research project or innovation program, perhaps in your business. You might want to consider if you would release important project data from your business as a press release. Thank you for watching this presentation. Do take care of your intellectual property.